participated in essay competitions. That also there are few occasions they are the champions. Our students participated in almost every legal events, seminar, conferences, and our faculty is also participating in national, international conferences also. I was also last September in London in connection with one conference. So, law school, Brit Law School is one of the private law school growing very fast, and I hope when next time we will visit India, of course we will visit our law school. Many feeders will be added to our law school. I hope you will again visit our law school. And before to start your lecture, it is our convention to have a felicitation with our some memento which is prepared by his students. So I will just this is our let us now request Professor Santiago to deliver this lecture. If you require, you can call on microphone also.
Okay.
It will be confident. Where is Jahangir?
Can you hear well back there? Let me try it without, like you did, and we'll see. So, thank you so much for this presentation. If I ever
So he asked for a video recording. Yeah, so
I
we're doing
would
that
have
one.
further
Por que
reason
você?
to also come to kids to Bhubaneswar, and that is, I think we'll do without. How can you hear here? More or less. Okay, let's have it. I said I have this further reason to come, namely that your school is the first school that has received me. So, is it better now? So, out of gratitude, I have another reason to return if I ever come back to India, which I hope I will. I don't know if it has happened to you, if you have ever presented, like for example, some students, they presented today in a class that I had the pleasure to attend earlier in the morning in the honors course of constitutional law, the number 6, I believe. So if you have ever presented in any contest, in a moot competition or whatever, you always prepare some notes, you prepare what you're going to say, and it always happens that in the intervening time between the time you make those notes and the time of your presentation, something happens, some new things that you may want to bring to your presentation. You watch a movie, a film, you go to the theater, you participate in an accident, you're killed. No, if you're killed, then you won't present. Well, for example, I had my notes for today's presentation on comparative constitutional law, and I didn't count on going out for a walk last night around the campus and having a couple of interesting conversations with people. I didn't count on attending this lecture earlier today where some students that are sitting to my right here and to my left here said things that are relevant to what we're going to say. For example, let's start with last night. A person who was kindly entertaining me yesterday evening and helping teachers told me, you know what, be prepared because in the audience there will be several students that like to participate, that like to ask questions, that like to talk. So now I decided I would count on that to ask, for example, I can ask you, so that we don't do the typical thing you don't want to do if you are an instructor, and that is to address the public in general. For example, this general question. Do you know what is taught at Kitt's Law School under the name of comparative constitutional law? You never do that. You do this. Could you, Miss, tell us if you know what is taught here under the label comparative constitutional law? Now, if you don't, because, I don't know, you haven't taken that class, you don't want to talk, etc., you just say, no, sir, I don't know. But if you do, then perhaps you could contribute with an answer.
Yes, sir. In our comparative constitutional law.
Can you speak up, please, so that they can listen back there?
Sir, we actually pursue here comparative constitutional law, in which we do the comparative study between mostly the U.S. Constitution and comparative study between the U.S. Constitution and the Indian Constitution, and there we have various categories of schedule or syllabus, in which there has been a division as to the evolution of the due process of law, and the evolution of the trade and commerce clause, and how there is a difference between the evolution in India and in US. Mostly this is
That is more than helpful. Thank you very much. Now, let me ask further. For example, I can ask you. Your fellow student here mentioned some topics that are covered in that constitutional analysis. She mentioned, for example, due process. Do you know of any other topic that is covered in that class of comparative constitutional law?
Ponu, speak up. Come on. Speak up.
Can you speak up, please?
Sir, I just recently I just moved to third year, sir. So I studied
Speak up, yaar. तुम
That's a
बोल क्यों नहीं?
very good answer. Because he speaks the truth. So it's a very good answer. So can I ask you, do you know what topics other than due process?
Sir, actually I'm second year.
You are? That's another good answer. And what about you for Then I'll go for
Professor,
an easy one.
anyone
Yes.
in the second and the second rows?
No, but these guys I already know. For example, you there. I've talked to you already, but I haven't heard you.
Sir, in comparative constitutional, we have done the judicial review.
Judicial review. So due process, judicial review. What else?
Sir, trade and commerce, we have done the
She had
countries
mentioned that, yes.
Australia, USA, India, Canada.
Okay.
Basically 3-4 countries. And
So US, Australia,
Canada and India.
and not the UK.
Even UK.
Even UK. You see, what I notice here is a permanent problem when you come to decide what to teach and what to study, when you teach and when you study comparative constitutional law. One problem is what jurisdictions will you cover? The other problem is what topics will you cover? Now, I will tell you, by way of introduction, that in my view, it is more important the problem of what topics will I cover than the problem of what jurisdictions will I cover. The problem of what jurisdictions constitutions will I cover is more contingent, and of course India will choose jurisdictions to which it relates more for some reason, as one could easily guess that India relates to the British Constitution or the Canadian or the Australian or the American. But then, with the problem of topics to be covered, there is a great temptation that consists of trying to cover as many as you can, as if teaching comparative constitutional law were a quantitative problem, as if the more in numbers, the more jurisdictions, the more topics you cover, you will learn more, which is not necessarily so. There is a Latin tag that I find very useful as applied to comparative constitutional law. I would have liked to write it on the board, but I will have to depend on your proficiency of Latin, which is, I'm sure, dubious, that I should depend on your proficiency of Latin, but anyways, I don't depend on mine, please. The tag goes non multa sed multum. Now I know enough of Latin to know that the letter A in multa, many, multa, is a plural, and the un in multum is a singular. Non multa sed multum. Not many things, but much. So the difference between many and much, a very rich difference, is captured by the difference between multa and multum. You can know many jurisdictions, you can know many topics without knowing
Much about them.
much. Like all other important things in life. Take love, for example. It's not about many, it's about much. So, do you know much about cricket? Well, that's not about having watched many matches necessarily. You can have a lot of information without knowing much. This same applies to our discipline today. You can know loads of things. Can we turn off this, please?
Yes.
Can someone help me? Because he has an example. Thank you. Thanks. By the way, this has also relevance when you come to think of what it is to be a good law student or a good lawyer. You know, the good lawyer, and therefore the good law student that will become the good lawyer, the good attorney, etc., is not a machine that spits legal information, that knows many things, that knows that no, that is not Article 73 of the Constitution. It's Article 74. I mean, anyone can know that. You just check that the person who is speaking stumbled and said the wrong article. But a different thing is to know what your good professors know, namely, to know much about whatever discipline it is. You can tell. Same about a lawyer. Who is the good lawyer? He's the person who Not the one who knows loads of things, but the person who has a clinical eye, like can smell where the solution is. Right. Therefore, my belief is that when it comes to comparative constitutional law, it is best to focus on only a very limited number of topics and go deep, deep, deep into those topics. Say, judicial review, the right to life, due process. You need to select them well and not do too many so that you can go deep and subsequently know much. So I wanted initially to prevent you from falling in that temptation, in that trap, when thinking through the topic of comparative constitutional law. It is best to really master, to be proficient about one, maybe two, maybe three topics, than, okay, what is comparative constitutional law? Let's now move to that next problem, and I will borrow again from today's presentation by some of you in this class I attended in the morning. At some point, one of your fellow students sitting here to my right mentioned Lord Diplock, a speech by Lord Diplock, I assume in the House of Lords in the UK, to justify something. It was actually not him, it was, I believe, was it the Supreme Court that was quoting Lord Diplock?
Yeah. Yes. The Supreme Court was good. Yes.
So it was the Supreme Court of India quoting Lord Diplock. So more or less disingenuously, I asked him, but why would they mention Lord Diplock so happily if whatever he says is not part of the law of England? Excuse me, it is part of the law of England. It is not part of the law of India today. Well, he said, you know, we have here this tradition, this custom of sticking to important British decisions and court decisions of India, of the Indian Supreme Court or whatever. Well, you know, I haven't thought about this when I prepared the notes for today's presentation. But this problem, the problem of the Indian Supreme Court giving some authoritative value to Lord Diplock's speech, is not far removed from the problem of what is comparative constitutional law. Why? Because comparative constitutional law is precisely about applying foreign sources in your country. Sources that do not have in your country what? They do not have authoritative value. So your judges, they are not bound by those sources, and nevertheless, under comparative constitutional law considerations, they follow those sources. Or, to put it differently, exercising comparative analysis, they apply something that otherwise would be misplaced. That's, in a nutshell, what comparative constitutional law is. I'll give you a couple of examples. Now, but before I do so, here in the School of Law at KITS, and in the US, and in Argentina, and in Kenya, you address comparative constitutional law as an academic discipline. the practice of the courts, the practice of applying foreign constitutional materials. But then, the study of that practice becomes what you study in school, under the label comparative constitutional law. So when your fellow student here was telling me that you go through materials on due process, what is it that you do? You study court decisions, precisely. That what did they do? They went through that comparative analysis. So even though some of you know examples of comparative constitutional analysis in court decisions, let me give you a couple for those of you who haven't taken the class yet, and so that those who have a different angle to it. First, an example of the U.S. The U.S., it's interesting to bring an example of the U.S. because the U.S., as you know, they have the oldest constitution in force in the world. It's from 1787. The Constitution of Argentina, my country, by the way, is the third oldest constitution in the world. It has been in force since 1853. But before this, the first one, the American one, I was saying bringing an example from the US is interesting because since they have this very old constitution and they have well-established constitutional practices, they were always reluctant to accept comparative constitutional law. The use of foreign materials was okay in commercial law, in patent law, in property law, and that was called comparative law. But no, we won't do it, they would say, in constitutional law. Why? Well, this has been described as a kind of provincialism or insularism. We want to isolate ourselves from foreign corrupted practices in an area that is so sensible and in which we have sensible solutions. It is sensitive and we have a very sensible solution in our own constitution, so we don't want contamination. But this has changed. This has changed especially after the 1950s. First, the change happened in law schools. From the 1950s on, many law schools in the United States started to have courses titled Comparative Constitutional Law. In the year of 1950, a very important article documents the existence of 26 law schools. In 1950, 26 law schools that offered a course called Comparative Constitutional Law. A year where almost no one in the world studied comparative constitutional law. Only some people in France and in Spain. Now if you jump to the present, every single US law school offers a course in comparative constitutional law. Furthermore, in the year of 2005, 2 of the 9 US Supreme Court justices, namely Justice Scalia and Justice Breyer, they had a debate that was broadcasted on national television and that made the front page of the New York Times the day after the debate took place. And the debate was entirely on
Using
comparative
comparative
constitutional
constitutional
law. So imagine 2 judges of the highest court of the land that always have been very reluctant. In fact, one of these 2 justices is very reluctant, but he accepted to debate the topic, therefore assigning it a very big prominence. So much so that, as I said, it was covered by the national press and a very high-profile way. This coincided with the Supreme Court deciding one of these cases I was going to bring to you as an example. And 2002 case on capital punishment. It's a capital punishment in the particular case of mentally handicapped people. That is, people that, according to a legal definition, were mentally handicapped at the time um, of doing the crime that deserved capital punishment. So, in this case, a divided court quoted extensively in the majority opinion decisions from the European Court of Human Rights and from other international non-court bodies, international organisms, etc., that were against the capital punishment in these cases, and also in the cases of minors. So the court, the U.S. Supreme Court, without treating those decisions as binding or as authoritative, the court used them to support its own independent judgment that in those cases it was cruel and unusual to apply capital punishment. Cruel and unusual, as you know, are words taken from one of the amendments to the Constitution of the United States. Now, this is my first example. Then I'll give you an example from my own country, and after I give you that example, I'll make a couple of reference that both cases have in common. The example from Argentina is a case in which petitioner, an NGO that undergoes in human rights litigation, sought an injunction so that an image of the Virgin Mary would be removed from the main courthouse in Argentina. The reason that the petitioners gave had to do with the neutrality of the state and the fact that as a consequence of that neutrality, you couldn't have a religious image of one religion, the Catholic religion, in prejudice of other religions or in prejudice of the absence of any religion. Now, this NGO, when they started the litigation, they quoted a U.S. Supreme Court precedent in a case called Lynch. See how interesting. The U.S. Supreme Court quotes the European Court of Human Rights for their case, and the Argentine court quotes the U.S. Supreme Court. And the U.S. Supreme Court, in that case, that was a case about a crash. Is crash a clear word here? Maybe there is another word to refer to this, or maybe there isn't. I will describe what I understand as a crash.
Place where newly-born babies are sent by the mothers are born.
Yes, this particular crash was a crash for baby Jesus with the Virgin Mary and Saint Joseph that a Protestant group in the United States, not Catholic but also Christian, they had placed in front of a courthouse. And the Supreme Court, in the U.S., when they were requested to remove the crash, the nativity, if you want to call it, they said that religious images could not be placed in courthouses, but that the crash had an independent secular meaning, because there had always been this sort of images, said the court in the U.S., in that state of the United States. So, in the Argentine case, the NGO petitioner said within a creche, it would be okay because it would have an independent, secular purpose. But this is the Virgin Mary. People come here to pray. So this is religious. This is, whatever it means, there are more principles in constitutional law than in bankruptcy law. My queries, my concerns rather remain. I wouldn't borrow any principles without the constraints that I mentioned. Saying that the use has to be obiter, even the use of principles, I don't find it technical at all. The word is Latin, but it's not a technical idea. It's the very basic idea that you don't substitute your law, not even your principles, for other principles unless you do it through the mechanisms, the procedures established by the law itself, not through court decisions, not as I do. I really liked the idea or rather, not the idea I had already expressed, the term inspirational exercise. That's what comparative constitutional law has to be. An inspirational exercise. It's inspiring, it can help, it's not something technical, it can help me teach the people what my law is. I'm a judge, so I quote this, it explains it better, but it's not an applicational, I think he said, exercise. That was nice. The idea for you, sir, of the talisman, following law of certain countries as a talisman can be helpful. You may be wanting to explore it. It has been used by Jonathan Miller in the United States, suggesting that countries take foreign decisions that have a lot of prestige to give talismanic effect to their own decisions. So I think you're quite correct that this talismanic effect exists with regard to US presidents or British, and not, I don't know, of those of Russia or the Philippines. So there with talismans, you need again to be careful with manipulation, because you can use a talisman for the wrong reasons and with bad consequences. As to globalization and what you said about social rights, what you said about globalization of rights, I didn't have time to get into it today, but it's in the full version of the paper. I think it's important to understand why it's less relevant. What unites us is more relevant when we talk about the right to life, the right to move, the basic equality. Go to environmental questions. Well, it isn't so easy or clear for me to say that the right to life and my right to a clean environment are exactly the same, because you won't get a clean environment by doing like this, and then the difference between positive and negative is of course very important. Manby, Illinois, well, incredibly enough, I know the case, I'm familiar with it, but I don't remember it well enough so as to answer your question. The value of dissenting decisions or things said in dissent is or should be zero in terms of precedent, in terms of authoritative value. But again, if you quote Lord Ditlock, more so can you quote a dissent of the Indian Supreme Court. Obiter dictum, as I see it, but I don't know. Perhaps I need to know more here about what is the standing of British law today in India. Something about which I'm quite ignorant.
Just to,
Yes.
can I just say, just for a second? In fact, what you said about dissenting opinions, let me tell you that this whole interpretation of life that you've been hearing around from the students is based on a dissenting opinion in Mann versus Illinois. Justice Field's dissenting view is the basis for this entire expanded interpretation of life that you see in India today.
Well, you see, but that dissent subsequently was incorporated into majority decisions. So once that happens, even if it was a mistake, then that's the law in the U.S., not here. That's a majority opinion. So who was it that expanded your comment? Not maybe not yours. There, over there. Yes, so you might be interested in, and there is a quote I have in my paper of something that the present Chief Justice of the United States,
John
Chief
Roberts.
Justice Roberts,
John
something
Roberts.
he said when he went through the hearings that they go, the nomination hearings
Before
before
this-
he was appointed.
Before the Senate.
So they were asking him what he thought about comparative constitutional law, and he said, this has to do also with your concern. He said the way comparative constitutional law is used sometimes is like looking at a crowd and picking who are your friends, which reminded me of the mental exercise that you suggested to us. And that has to do for you, and especially for you, with what Justice Scalia, who is against the use of foreign constitutional materials. I am not. I told you that with certain constraints, I think it's something good. He's completely against, and one of the reasons he's against is that he dislikes what he calls the selective use, not too different from manipulation. He says, why is it that you look at those countries when you decide capital punishment cases where the right to life is at stake, and you don't look at them when you decide the abortion cases where also the right to life is at stake, but those are pro-life countries. They never accept abortion, and you completely ignore them. You don't even mention them in cases that were decided like 3 years apart, similar to your inconsistency question. So I stop here. I will remain here a few minutes. I thank you very much for your attention, and I look forward to seeing you again.